Imagine it. Government officials arbitrarily deciding who's worthy of exercising their constitutional rights and who's not. That was exactly the case in the Old South, as Jim Crow laws were put in place by racist officials in order to deprive blacks of their rights, including their right to vote. In California, law-abiding gun owners don't have to imagine what that's like. For nearly a century, the only way you could exercise your right to bear arms for self-defense in the Golden State was to get the permission of a politician. Well, now we have California's Attorney General Kamala Harris and the Sacramento Bee standing up to defend this very same kind of discrimination. They support the policy of subjectively determining who can and who cannot defend their lives. They believe that no objective standards are needed. Well, just because we're talking about guns and gun owners. Anything they can do to limit the number of armed Californians is a good thing in their minds. The Ninth Circuit Court of Appeals struck down California's subjective policy because it represented exactly what the Constitution was designed to limit: government abuses, discrimination, and favoritism. Now that scares some big city government officials who want to keep carry licenses as perks for their friends and donors. Take, for example, the recently retired Los Angeles Sheriff Lee Baca. He refused to issue carry permits to thousands of trained, law-abiding Angelenos, while at the same time approving licenses for his friends and political donors. Then there was former San Francisco Sheriff Michael Hennessy, who made sure that his own lawyer was taken care of while subjecting all other San Franciscans to an outright ban on their rights. That sort of government corruption is why the founders made the Bill of Rights a part of the Constitution in the first place. After the Civil War, we said so once more with the ratification of the 14th Amendment. All people have fundamental rights, including, especially the right to keep and bear arms. In Moore v. Madigan, the landmark Seventh Circuit court case that overturned the state of Illinois' ban on carrying of firearms outside of the home, the court said the Supreme Court has decided that the amendment confers a right to bear arms for self-defense, which is as important outside the home as inside. Fundamental human rights are just that. They're fundamental. And they're not for those in the political class to allow or deny law-abiding people based on who gives them campaign contributions or who throws them a birthday party. As the majority opinion in the Heller case so aptly put it, the very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. The Ninth Circuit was right to overturn California's carry license policy. Arbitrarily discriminating against citizens by depriving them of their rights is clearly unconstitutional and just plain wrong. Shame on Kamala Harris and the Sacramento Bee for supporting such a Jim Crow-style gun law. My name is Craig DeLuz with CAL-FFL, and it's been a pleasure sharing with you.